This is Michael Popok, Legal AF. Sure, the Manhattan DA just filed a 64-page brief informing Judge Merchan what we all know, even if we didn't go to law school, that the conduct that Donald Trump was convicted of in 34 counts in New York has nothing to do with his official presidential conduct, his constitutional powers, even the outer boundaries of his official conduct. It's nothing of the sort. It's all unofficial private conduct about a private affair that he was trying to cover up using his private attorney, writing checks on a private account in a private checkbook, responding to invoices that were sent to him in his private capacity. That means that even under the July 1st decision by the United States Supreme Court, there's no immunity. And for Donald Trump to say, well, there's immunity. First of all, let me be clear. In his briefing, Donald Trump's own briefing, he does not take the position that the conduct that he was convicted of is somehow immune. Let me repeat that. He does not say, Donald Trump, that the conduct of the private affair, the private cover-up, the sex act, the payments are immune. He argues that the evidence that came out about his tweets while he was president, the meetings he held while he was president, the interactions with Michael Cohen while he was president, the payments made while he was president, the conversations he had with certain people, his White House communications director, Hope Hicks, or his administrative assistant, Madeleine Westerhout, that they were somehow privileged evidence. And therefore, since they're evidence of an official conduct, therefore they should not have been presented to the jury, and therefore the jury wrongfully convicted. Let's pick that apart, just as the New York attorney, just as the Manhattan DA did. First of all, what they're trying to do, what Trump is trying to do, is trying to ride the rail that's inside of the immunity decision from December 1st that says that even evidence of official conduct cannot be used as part of the prosecution. But that's not what was done here. The fact that Donald Trump happened to be wearing the hat of it had a White House pass on the day that he met privately with Michael Cohen, paid him privately out of a private bank account for a private conduct to cover up a private affair. See where this is going? That doesn't mean that evidence is of official conduct, that therefore under the July 1st United States Supreme Court decision should not have been presented to the jury. But fundamentally, Donald Trump had the obligation, along with his lawyers, to preserve this issue for appeal through objections at trial, to let the trial judge in the first instance make the ruling, and to let a federal court judge, when he popped out to federal court early in the case, a summer ago, in order to try to transfer the case from state to federal court, he made certain of these arguments, but did not preserve these arguments. See, Donald Trump, as the New York Court of Appeals, the highest court in New York, already established, if you know or should know that there is a chance of a change in the law, because the briefing is pending, for instance, because you've raised the issue, you have to preserve the possibility of the change in law for your appeal. You can't say, well, the law changed after my case was over and now I want to take advantage of it. You need to preserve and say, we're objecting at trial. You would say, we're objecting to this testimony and we move to preclude it because it deals with official conduct and therefore is immune and should not be used at trial. They never raised that argument. The only objection they made to Madeleine Westerhout had nothing to do with immunity. Same thing for Hope Hicks. And they also, as pointed out in the first part of the brief for the Manhattan DA, Donald Trump, when he popped out and filed a motion to remove the case to federal court, and he was in front of a senior federal judge, he never preserved the issue of immunity. He argued that all of his acts were official conduct and therefore immune. The judge rejected that, the judge having found that a private sex act between two people, just because one guy happened to get elected president later on, doesn't render this official conduct or within the colorable outer boundaries of his official conduct, which is consistent with what the Supreme Court said is the proper analysis. Having made that ruling, Donald Trump never appealed. He never perfected his appeal, and he never took an appeal of that particular decision. So that's waiver. That's lack of preservation of an issue for appeal, which means you've waived the argument. And that's the first argument by the Manhattan DA. That's waiver. You didn't preserve it at trial to let the trial judge address the issue, and you didn't preserve your appeal on immunity issues when you try to take it to federal court. You didn't go to the Second Circuit on this issue. Now, Donald Trump knows his way to the Second Circuit Court of Appeals because he did it in the E. Jean Carroll case unsuccessfully, including raising immunity. So he knows how to do it. He just didn't do it. A lot of moving parts. A very stretched, thin legal team headed at one point by Alina Habba. They screwed that up. And the Manhattan DA made him pay for it in the brief. And the last argument in the brief, which is why this is going to win. Let me not bury the lead. Judge Merchan is not going to find, and neither is the Court of Appeals or the Appellate Division Court of Appeals going to find that the conviction should be overturned based on the United States Supreme Court decision. And he's not going to be able to go to the United States Supreme Court on this issue either. And so the last major argument is that this is not official conduct at all. It is classic, unofficial, private conduct that even this United States Supreme Court would see that way. And that the narrow grounds for absolute immunity, which is things that come right out of the powers of the president in Article 2 of the Constitution, is not applicable. And this isn't even if you stretch, the Manhattan DA said in their brief, even if you stretch to the outer boundaries, the official conduct of the president, that is not going to cover what happened here. And then lastly, it's harmless error. The last argument, and it's probably one of the strongest ones, is that there is a mountain, an overwhelming amount of evidence that was used to convict Donald Trump by this 12-person jury. And these couple of stray, very minuscule pieces of evidence, even if they were official conduct related, and therefore should not have been presented to the jury, they were not outcome dispositive. They did not lead the jury to conclude and convict Donald Trump. They had other evidence. They don't have to hear about the official conduct issues of Madeleine Westerhout when she was the executive assistant scheduling the president's day. They had Michael Cohen testify. They had thousands and thousands of pieces of evidence. They had hundreds and hundreds of hours of witness testimony. And so if Donald Trump can't prove, and he cannot, but for that evidence about Madeleine Westerhout scheduling, Hope Hicks's comments as press secretary, a Federal Election Commission form, if it wasn't for that, Donald Trump would not have been convicted. He can never show that. He can never show that it was outcome determinative because the evidence is so minuscule, given the vast, overwhelming amounts of evidence presented on the scale to the jury, that he'll lose on that grounds alone. So there's four major grounds that the Manhattan DA has that they're going to prevail on. Failure to preserve the objection for appeal, failure to properly preserve the issue for appeal, failing to perfect the appeal once you lost on that immunity issue last summer. Okay, that's one. Two, so you didn't let the judge make the first issue, right? Then you have, this is not official conduct that should not have been presented to the jury. This is classic, unofficial, private conduct about a private affair. The immunity decision does not control. That's their second major argument. Their third major argument is even if it were not proper to allow that in, then that is it is harmless error because it's not outcome determinative. There's so much other evidence. So you've got those as your grounds for Judge Merchan picking and choosing among all of them or any of them to deny Donald Trump's motion to vacate his 34-count felony indictment. I know everybody was all excited on the Republican MAGA side when the July 1st ruling came out, trying to map it onto all these various cases. And they said, oh, we're gonna bring it against the 34-count felony conviction that just happened. The problem is even Donald Trump in his own moving papers is not claiming, because he can't, that all the bad stuff that happened when he was candidate Trump is somehow covered by the immunity decision. So they have to go down that narrow path of arguing that, well, it's not official conduct, but certain parts of the evidence stream that was presented to the jury is official conduct. And therefore that should not have been allowed. And that changed the outcome of the case. But they can never get to that last causation link, that it was outcome determinative. They're going to lose with Judge Merchan. Quickly, there's one more brief that's due because it was Trump's side brought the initial motion. They get a reply brief in a couple of weeks. But sometime in the middle of August, we're going to get a ruling from Judge Merchan that's going to say denied. They can then try to take their appeal. And he will, I'm sure, postpone the sentencing because there's a sentencing hearing in September 9th, I think. He'll postpone a sentencing until they wrap through these appellate issues. And then he's going to sentence Donald Trump. And by that time, Donald Trump will have likely lost the election, and he'll have no leg to stand on for whatever the ultimate penalty imposed by Judge Merchan is going to be, because it's the judge that sentences, not the jury. We'll follow it all on the MeidasTouch Network and on Legal AF right here on the MeidasTouch Network. Follow me, Michael Popok. Go over to the MeidasTouch Network YouTube channel. Look under playlists. Got confused for a minute. Contributors. Look for Michael Popok, and there's my name, and you'll find my entire body of work. And Legal AF, don't forget, Wednesdays. Saturdays, 8 p.m. Eastern Time. It's lawyers talking about things they know what they're talking about at the intersection of law and politics. How refreshing. Wednesdays, Saturdays, 8 p.m. Eastern Time, right here on this MeidasTouch Network, and then on every audio podcast platform of your choice. I'm breathless. Until my next hot take, and until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.